She is widely recognized as an outstanding jurist, scholar, and a person of great integrity. Please join me in welcoming Justice Sandra Day O'Connor.
Each of you have one of these reprints of her block cartoon when I was nominated for the court, with Lady Justice holding the scales and peeking out under the cover over her eyes. Well, it's about time. Well, it was. It took 191 years, so he got that right. And I'm very... I'm honored indeed to be selected for this event because I admired Herb Bloch's work so much, and I wish I had known him, maybe in the next world. But it's elementary high school civics that we have three branches of government which regulate and limit each other's power by a system of checks and balances. Congress makes the laws, the president enforces them, and the judiciary interprets them. And it sounds simple, but of course, it often is not. And the main way that the judicial branch can exercise its constitutional power to check the other branches is by declaring statutes or executive acts unconstitutional. Although sometimes judges might check the political branches in a gentler way, merely by interpreting a statute in light of constitutional values, or by ruling that a regulation or executive act is not authorized by statute. This also means that judges have the power to make the other two branches really, really angry. And if we never did so, we probably would not be doing our duty. But the judges cannot play their role if they have to worry that they will be subject to retaliation for their judicial acts. As James Madison put it, and after all, as the father of our Constitution, he ought to be heard. He said an independent judiciary is an impenetrable bulwark against every assumption of power in the legislative or executive. Well, impenetrable may be putting it a bit strongly, but his basic idea is right. If you believe, as James Madison did, and as I do, that the courts are important guardians of constitutionally guaranteed freedoms in our common law system, you know that that system breaks down without judicial independence. By that, I mean the freedom of the judge to make the decision the judge determines is correct. Now, why is judicial independence important? It's because judges, like the other branches, have a constitutional task as well as a constitutional power. Congress must implement the will of the people as it enacts laws. The executive must faithfully discharge those laws. And judges must faithfully and neutrally interpret them, with only reason, precedent, text, and experience as the guides. Courts are designed to be places of reason, argumentation, and fidelity to the laws, where the people may bring their disputes from the monumental to the mundane and know that they will be fairly heard. In order to be fair and faithful to the law, we must not follow the prevailing winds or shrink from our judicial duty because the path of the law leads us to an unpopular place. Of course, judicial independence is not always easy to define. Judges can be subject to discipline for legitimate reasons, and the political branches properly control, to some degree, the jurisdiction and the political makeup of the federal courts and of the various state courts. Still, some techniques for influencing the judiciary are pretty obviously out of bounds. For instance, suppose during a period of stormy relations between the White House and the Chief Justice, the president's security guards kill the Chief Justice's pet cat. Or suppose the executive branch threatened to cut the water supply to the Supreme Court building to prevent the court from meeting there and making anti-presidential statements. Or suppose the cabinet tried to evict the Constitutional Court from its offices. Well, now the first two events actually happened in the early to mid-1990s in Russia under President Yeltsin. The third happened in Bulgaria in 1995. Now, I think those of us here tonight could agree that's not judicial independence. Judicial independence doesn't happen all by itself. It's tremendously hard to create, and it's easier than most people imagine to destroy. Our tradition of judicial independence began in England, 80 or so years before our Constitution was adopted. That was when the British Parliament passed the Act of Settlement of 1701, which limited the succession to the British throne to Anglicans, but also, more importantly for us, provided that judges there would hold office and draw their salaries during good behavior. Now, we have Article 3 of our Constitution, which says basically the same thing, except without the part about the Anglicans. Now, as you can read in the Federalist Papers, it's anonymous, but I will tell you this was written by Alexander Hamilton. He said, "The complete independence of the courts of justice is peculiarly essential in a limited constitution. By a limited constitution, I understand one which contains certain specified exceptions to the legislative authority, such, for instance, as that it shall pass no bills of attainder, no ex post facto laws, and the like. Limitations of this kind can be preserved and practiced no other way than through the medium of courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. Without this," said the Federalist paper, "all the reservations of particular rights or privileges would amount to nothing. This is why," says Hamilton, "judicial independence is especially important in the American system." Some concrete examples can help make clear what Hamilton was talking about. Perhaps the most important one in the contemporary era is Brown versus Board of Education, which held that the Equal Protection Clause of the 14th Amendment forbids racially segregated public schools. Brown was a decision of principle, and it had the support of a unanimous court. On the day it was published, May 17, 1954, Associate Justice Felix Frankfurter wrote a note to Chief Justice Earl Warren, pronouncing that this would be a day that will live in glory and a great day in the history of the court, not least for the course of deliberation which brought about the result. The court put off deciding how to implement that result until the next year, in Brown 2, as we call it. But that did not diffuse the anger that the decision would cause. I don't have to remind you of what the response was when the Brown decision was finally implemented. Some states refused outright to comply. It took the National Guard to integrate the schools of Little Rock, Arkansas. And of course, the resistance was not just at the state level. Many of the black students who were at the front lines of desegregation were treated miserably and were hounded out of the schools that they had fought so hard to get into. Today, much has changed. Our schools are no longer segregated as a matter of law, although many of them are still segregated as a matter of practice. But one thing is certain: it is no longer possible to run for office in this country or be nominated to be a judge and to oppose the idea of integrated education. but it took the commitment of almost all Americans to this constitutional principle to bring this about. United States versus Nixon is another important example of judicial independence. This time, in the name of separation of powers and constitutional and governmental transparency rather than civil rights. This decision, the Nixon decision, was also unanimous. But what makes it noteworthy is that 4 justices in particular put their name to it, the 4 members of the court who had been appointed by President Nixon. A district court had ordered the president to turn over tape recordings of his conversations with aides. In a criminal trial where 7 of his staff members were charged with obstruction of justice and conspiracy to defraud the United States, the president claimed executive privilege and appealed the lower court's order all the way up to the Supreme Court. Well, you know how the story ends. The court ordered the president to comply with the subpoena, and he did. And he then immediately resigned from the presidency. A lesser but no less interesting example of judicial independence comes from the case of Hepburn versus Griswold, which was written by former Chief Justice Salmon Chase. This case was a constitutional challenge to the greenback laws, which created a national paper currency. The Legal Tender Act was passed during President Lincoln's tenure. The man largely responsible for it was the Secretary of the Treasury, Salmon P. Chase. Chase helped design the law and helped push it through Congress. He even put his own face on the $10,000 bill. Maybe this was because he had political ambitions, which he did. President Lincoln considered paper money essential to the Civil War effort, but the law was constitutionally controversial at the time. So controversial, in fact, that when President Lincoln had to appoint a new Chief Justice of the Supreme Court, he wanted to find someone who could be trusted to uphold that law. So he selected none other than Salmon P. Chase. Now, this must have seemed like a pretty safe bet, but Lincoln was in for a surprise. Once Chase was on the Supreme Court, he saw the issue differently. He became one of the deciding votes to strike down the greenback laws as unconstitutional. Chase was caught on the wrong side of history on this one. That decision was overturned the next year, and no doubt for the best. Nonetheless, it stands as a striking example of judicial independence and a warning to those who pick judicial nominees with a particular political issue foremost in mind. Well, fortunately, most of the time, politicians don't challenge the courts to come and enforce their judgments themselves, as Andrew Jackson did, President Jackson, in the wake of the Supreme Court's decision in Worcester versus Georgia. But the value of judicial independence is a lesson that some of our current leaders may not have learned. In a recent speech at a conservative conference, a prominent House leader said that judicial independence does not equal judicial supremacy. In particular, he faulted the courts for their decisions on abortion and school prayer and for improperly citing international law. This was after the Terry Schiavo case, when the federal courts applied Congress's one-time-only statute as it was written, but perhaps not how the congressman wished it had been written. In response to this display of judicial restraint, the congressman blasted the courts for ignoring congressional intent. These are not examples of a mature society, he said, but of a judiciary run amok. Speakers at that conference advocated mass impeachments of judges, stripping the courts of jurisdiction to hear certain cases, and using Congress's budget authority to punish offending judges. Now, impeachment for a judge's judicial acts has been politically taboo since the failure of Justice Samuel, not Salmon, Chase's impeachment back in 1805. Jurisdiction stripping proposals are nothing new. although their use is no defense. In the 1950s, the proposals suggested stripping federal courts of jurisdiction over desegregation and domestic security cases. In the 1960s, the controversy was over the admissibility of confessions in criminal cases. In the 1970s, it was over busing. In the 1980s, it was about abortion and school prayer. Now we have the Pledge of Allegiance and gay marriage thrown into the mix as well. Congress has never given Article III courts as much jurisdiction as the Constitution allows, and frankly, most federal judges think they have quite enough cases as it is. And Article III allows Congress to make exceptions to the jurisdiction of the Supreme Court and to even abolish the lower courts entirely. The merits of all these measures are debatable as long as they're not retaliation for particular federal court decisions. Now, in all the federal courts, including the Supreme Court, death threats have become increasingly common. Judge Greer, who handled the Shivo case for over a decade, has received many menacing emails and death threats. And we've seen this before. Justice Hugo Black often wore a chest protector provided by the Secret Service when he visited Birmingham. My former colleague, Justice Blackmun, got death threats because of Roe versus Wade. His window was once shattered by a gunshot. Well, some of these comments and suggestions about dealing with judges have come, well, I guess all of them have come from Republicans, but of course, Republicans are not the sole offenders. A former Democratic president complained in words that sound a lot like current congressional complaints that the court, meaning the Supreme Court, has more and more often and more boldly asserted a power to veto laws passed by the Congress and by state legislatures. The court has been acting not as a judicial body, but as a policy-making body. He accused the court of improperly setting itself up as a third house of the Congress, a super legislature, reading into the Constitution words and implications which are not there and which were never intended to be there. Like some members of Congress today, this former president paid lip service to judicial independence, saying, "I want, as all Americans want, an independent judiciary as proposed by the framers." But he made clear he did not mean a judiciary so independent that it could deny the existence of facts which are universally recognized. He believed in a government of laws and not of men. But he thought that meant we must take action to save the Constitution from the court and save the court from itself. The president's plan was simply this: whenever a judge or justice of any federal court has reached the age of 70 and does not avail himself of the opportunity to retire on a pension, a new member shall be appointed. Now, I'm sure you all remember that was Franklin Roosevelt's fireside chat of March 9th, 1937. He's the fellow on the dime in your pocket. Now, President Roosevelt was in many ways a great and important president, but this was surely not his finest hour. I'm not against limiting judicial terms, although the Constitution does not provide that for federal judges. A retirement age of, say, 75 or so might be reasonable. Anyone who's read some of my opinions knows I do not take a formalistic approach to these questions, and it takes more than reciting the mantra of judicial independence to get me worked up. But as I said before, I am against judicial reform driven by nakedly partisan, result-oriented reasoning. I close tonight, with a simple message, which unfortunately also seems to be timely. Judicial independence I see as a bedrock value of our constitutional system. Without it, there would have been no Brown versus Board of Education. With it, we know there will always be at least one place of refuge where the Constitution can be enforced, even if it angers the other branches of government. We must, therefore, be vigilant against those who would strong-arm the judiciary into adopting their preferred policies, or who seek to undermine the ability of the courts to play their constitutionally ordained role. And this is where all of you come in. There is no natural constituency for judicial independence. And although judges have a bully pulpit, in a sense, in the courtroom, they're largely disconnected from the media and the public. Judges rely on ordinary citizens to defend their constitutional structure. And we rely on responsible journalists to get the facts before the people and to look beyond the sloganeering that characterizes so much of our political culture today. Criticize judges when mistakes are made, and they are sometimes. Go ahead. But don't disparage the difficulty of the judicial task, and don't undermine the bedrock requirements for judicial independence. If we are to be, as John Adams once said, a nation of laws rather than a nation of men, then we're a nation in need of its judges. And it is for you and other Americans to be dedicated to the promise and the practice of our constitutional heritage, which makes the courts, armed with the power of judicial review and protected by judicial independence, part of the people's arsenal to enforce the rule of law and to protect individual freedoms. Thank you.